Hello everyone, welcome to ixambee's law exam channel Legal V. Today we are going to discuss the fourth legal maxim, and I gave you a situation about it yesterday. On the face of it, it is very clear it relates to dying declaration, section 32 of the Indian Evidence Act. A was a person who was on his deathbed and he gave certain statements related to the circumstances of his death to B. I asked you whether these were admissible or not, whether they are valid or not. These fall under section 32 of the Indian Evidence Act. Section 32 subsection 1 talks about dying declaration. And the maxim which relates to this is Nemo moriturus praesumitur mentiri. Whenever you see the word Nemo, इसका मतलब होता है no one. And this praesumitur is obtained from the word presume. Moriturus means about to die. So when we are talking about this legal maxim, we are saying no one, no person who is about to die is presumed to lie. That means a person on his deathbed is presumed to always say the truth. No one at the point of his death is presumed to lie. And this maxim relates to dying declaration. Let's understand the key points. ये माना जाता है कि एक इंसान जो अपनी डेथ बेड पर है, जो मरने वाला है, वो झूठ बोलकर किसी को फंसाएगा नहीं. He will not falsely implicate any innocent person. So whatever he is saying on his deathbed is presumed to be true. There are two reasons जिसकी वजह से dying declaration is admissible. First is the necessity. अब जिसने क्राइम होते देखा है, अगर वो डेथ बेड पे है and the person is about to die, तो ये प्रिज्यूम कर लिया जाता है कि वो अब क्राइम के बारे में जो भी बताएगा, जो भी उसने आई विटनेस किया है, वो सच ही बताकर जाएगा. क्योंकि अगर वो अकेला इंसान ऐसा है जो उस पर्टिकुलर केस में आई विटनेस है, पर्टिकुलर एविडेंस अकेले उसी इंसान का है, then in that case it becomes a necessity to admit his dying declaration. The second reason is this noble fact that a person on deathbed would not lie. As I have mentioned, dying declaration is present under section 32(1) of the Indian Evidence Act, and it is an exception to hearsay evidence. We have discussed about hearsay evidence in a previous video on res gestae. Hearsay का मतलब होता है सुनी सुनाई बातें. That means evidence should be given by that person who has actually witnessed it, who has seen it, who has heard it. ऐसा नहीं होना चाहिए कि अगर ए ने क्राइम होते देखा है तो वो जाकर बी को बता दे, बी सी को बता दे और सी आकर फिर टेस्टिमनी दे रहा है. दैट इज हियरसे एविडेंस. ए ने अगर आई विटनेस किया है, ए ने कुछ सुना है, तो ए ही आकर एविडेंस दे. दिस वी ऑल्सो स्टडी इन द डेफिनेशन ऑफ ओरल एविडेंस अंडर सेक्शन 59 of the Indian Evidence Act. However, there are certain things that are mentioned under section 32(1). Whatever statements are being said in the dying declaration, they should explain the circumstances of the death or the cause of the death. By the judgments, the court has also established certain grounds of admission of the dying declaration. The first ground is the person who is dying, जिसकी dying declaration है, he should be the principal eyewitness, and exclusion of his statement may defeat the ends of justice. अगर उसके एविडेंस उसके स्टेटमेंट को इंक्लूड किया ही नहीं तो बहुत ज्यादा नाइंसाफी हो जाएगी. इन दैट केस it becomes, as we were discussing, a necessity to include his statement. And the second ground is sense of impending death. This sense of impending death gives a sanction equal to the obligation of oath. जैसे oath लेने पर a person is assumed to be obliged to say the truth, similarly it is said that the sense of impending death, मरने की संभावना होने से एक इंसान झूठ बोलकर नहीं जाना चाहेगा. ये भी हो सकता है that a person does not want to go and meet the maker, meet God with a lie in his mouth. There are a lot of case laws which are based on the principle of dying declaration, and we will try to discuss some of the important ones. The first one is Pakala Narayan Swamy versus Emperor. In this case law, the expression circumstances of the transaction which resulted in his death has been eloquently explained. In this case, two principles were explained. First of all, the principle of confession, and the other one was dying declaration. There were two issues that were raised in this case. One was of dying declaration and the other was of confession. In this case, the deceased had gone to Behrampur to Pakala Narayan Swami's house to collect his debt. जाने से पहले उसने अपनी वाइफ को बताया था कि मैं जा रहा हूँ डेट कलेक्ट करने के लिए. Later on, the deceased dead body was found in the trunk in a tree cut into pieces. अब कोर्ट के सामने सवाल ये आया कि जो डिसीज ने अपनी वाइफ को जाने से पहले बताया था that I am going to Pakala Narayan Swami's house, is that included in the definition of circumstances of transaction which resulted in his death? क्योंकि तब तक expectation of death नहीं थी. The deceased did not know that he will die at the house of Pakala Narayan Swami. Here, the court gave this expression a very wide interpretation and even included the statement that he gave to his wife about going to Behrampur as a circumstance of the transaction resulting in the death. The next question related to confession. Though it is not related to this video, yet I will just explain it a little bit to just complete the topic of this particular case. Usually, what is confession? A confession is a statement by which an accused is suggesting that he had committed the crime. मैंने murder किया है. I have committed that theft. There are certain statements in that particular confession which are suggesting, which are inferring that the accused has committed the crime. In a confession, the accused either admit the term of offense or admit all the facts which constitute the offense. Merely an admission of gravely incriminating facts. So in this case, the Privy Council expressed the opinion that whatever statement has been given by the accused, it was partly a confession and partly explanation for his innocence. The next important case is of Queen Empress versus Abdullah. In this case, there were gestures and signs were used in the form of dying declaration. In this case, the victim's throat was cut with a razor, due to which the victim was not able to speak. When the statement of the victim was being taken, a lot of names were spoken in front of the victim, for which the victim was gesturing a yes or no by hand. When the name Abdullah came up, the victim gestured a yes. And whatever gestures and signs were given in the statement, they were considered a part of dying declaration. Another important case of dying declaration is Munna Raj and another versus State of MP, where FIR was also considered a dying declaration. In this case, it was said that when there is a situation where a person has died and when an FIR has been lodged and in the FIR the person has stated that his life was in danger, then it is relevant to record that FIR as a circumstantial dying declaration. Also, it was observed by the court in this case that corroboration of a dying declaration is not necessary if it can be relied upon, if it is credible, if it seems to be voluntary. Dying declaration can be declared as an exclusive evidence for the purpose of conviction. Another important case is State of Punjab versus Praveen Kumar and also Sudhakar versus State of Madhya Pradesh. In both these cases, the court talked about multiple dying declarations and the court stated if there are more than one dying declaration, then these dying declarations should be in continuity, they should talk about the same thing, they should be complementary to each other, they should be in resonance with each other. मतलब एक जैसी होनी चाहिए, एक ही सिचुएशन के बारे में बता रही हूँ, एक ही तरह की बात बोल रही हूँ. ऐसा नहीं कि एक डाइंग डिक्लेरेशन में कुछ बोल दिया, दूसरी डाइंग डिक्लेरेशन में कुछ बोल दिया. Then in that case, they will become contradictory dying declarations and then they cannot be relied upon. Another important case is Purushottam Chopra versus State and City of Delhi and Paniben versus State of Punjab. In these cases, there was not a magistrate present to record the dying declaration. And it was stated that the presence of magistrate is not compulsory. Dying declaration कोई भी record कर सकता है, जरूरी नहीं है कि magistrate को ही record करनी है. But there are certain circumstances, exact statements of the person should be recorded, should be reproduced. In these cases, it was held that the presence of magistrate is not compulsory. Then there is another case which is Kushal Rao versus State of Bombay. In this case also, it was held that corroboration is not necessary. No corroboration is required for a dying declaration if it is voluntary, reliable and credible. So these are some of the important case laws from the dying declaration. Remember which maxim we were talking about? Nemo, moriturus, praesumitur, mentiri. Now let me give you another situation and try to guess which maxim does this situation relates to. So there is again a person A. This person has been accused of committing the murder of B at Delhi. But this person A is saying that at the time of murder, I was not even at Delhi. I was in Mumbai. So what does this situation relates to? So can you guess to which maxim this situation relates to? A is saying I was not in Delhi, I was in Mumbai at the time of murder. iXambee is your one-stop solution for all legal exam preparation. At iXambee, we offer online courses for various law exams for IBPS, SO Law, RRB, Scale 2 Law, insurance law officer exams like LIC, NIACL, GIC, legal law officer exam like Coal India. We also offer banking law officer exams for Scale 2 recruitments for SBI, Central Bank of India, Bank of Maharashtra, PNB, Scale 2. These are directly for Scale 2. And regulatory body law officer exams also, RBI Grade B legal, SEBI Grade A legal, NABARD law officer exams. If you're interested, check out the demo course from the description. For any queries, you can write to us at hello@ixambee.com. You can call us on this number mentioned on the screen. Subscribe to Legal B channel to stay updated with such important information and content. Thank you.